Excellent. I can see people are joining at a great rate of knots, which is marvellous. But while they continue to do that, I'll just introduce myself and our team and go through a few housekeeping points. So for those of you who don't already know me, I'm Emma Radmore and I'm a legal director in our financial services regulatory team, and I'm one of the founders and co-editors of our Fin blog newsletter, which has created Fin Live for you. So just to go through the normal housekeeping, as I said, we've automatically muted everybody. Only the speakers will have their microphones on. Please do use the Q&A function that's on the right hand side of your screen to communicate with us either during or at the end of the presentations. When we finished our various presentations, we'll give various options to ask questions. We'll deal with as many of them as we can. If we run out of time, we can certainly get back to you afterwards. As you can see, we are recording the webinar, and after it we will send you a copy of the recording, so you don't need to frantically make notes, just enjoy your coffees and listen to what we've got to say. And just to keep you engaged, we have, as usual, got a few polls coming up throughout the presentation. We will be very interested in your views in the course of those as well. So that's the housekeeping done. Who are we? I've already introduced myself, and I'm very pleased to be joined today, first by Lucy Hadrill, who is a solicitor and one of my colleagues in the Financial Regulation Advisory team, and by Mandy Robertson, who is an associate in our Commercial Disputes Resolution team. And what we're going to talk about today is, first of all, Lucy and I are going to talk to you about the FCA's proposals for a consumer duty, take you through the discussion paper that was recently issued. Then we're going to have the part of the talk that might make you a bit hungry, because we're going to talk about cake, and more precisely, Mandy's going to talk about the actual lessons that financial institutions can learn from the Colin versus Cuthbert fight that has been going on for quite some time. And then after that, we're going to get back to the maybe not quite so exciting, but nevertheless very relevant, what's going on in the world of financial promotions. And then, as I say, at the end of that, hopefully we'll have time for a bit of discussion and questions and answers. So on that, and without further ado, I'm going to hand over to Lucy, who's going to start off on the consumer duty.
Thanks, Emma, and morning, everyone. We're actually going to kick off today with a quick poll, just to see how familiar people are with the consumer duty. So the poll should come up on your screens very shortly. We just want to know whether you've heard of it, whether you've read the consultation paper, and how much work you think it's going to create for your firms. But don't worry if you haven't heard of it, because obviously we're going to run through it in a second. So we've got the results, and the good news is that over half of you have heard of it, so that's a good start, but don't worry if you haven't, because I'm going to kick off now. So as some of you obviously do know, the FCA has recently announced proposals for a new consumer duty, which is intended to set higher expectations for the standard of care that firms provide to consumers. So I'll start off with a little bit of background before diving into the proposals themselves. The consultation actually follows a document that FCA released in 2018, its Approach to Customers document, in which the regulator acknowledged that a clear statement of expectations which goes beyond the existing principles was needed, and Principle 6 in particular. And I've popped that up on the slide there as a reminder. Principle 6 says that firms must pay due regard to the interests of their customers and treat them fairly. In terms of scope, the proposals relate to regulated products and services sold to retail clients, which is a very wide term, and it does include SME customers. And it should also be noted that the new rules will catch firms involved in supply of such products and services, even if they don't have a direct relationship with the end customer. In terms of timings, then, the recently enacted Financial Services Act requires the FCA to have made rules on the consumer duty by the 1st of August 2022. So the FCA therefore intends to consult on the drafting of the new rules themselves before the end of this year, with a view to implementing the proposed changes by 31st of July next year. So I think many firms who already comply with the existing principles and the TCF outcomes in particular will probably be wondering why this consumer duty is needed at all. Well, the FCA does acknowledge that many firms already demonstrate good practices in consumer protection. However, it wants to go further. The FCA says that there are still poor practices in retail markets, which can lead to consumers not always getting the products and services that best meet their needs. And I've put some examples of these poor practices on the slide there. So these include things like firms providing information which is misleading or which is set out in a way which is difficult for customers to understand, perhaps customers being sold products that aren't fit for purpose, or examples of poor customer service as well. And the FCA's concern is that these practices could lead to consumers being unable to make informed decisions, which may then result in them buying products that perhaps are risky or that are inappropriate for their needs. And it could also mean, of course, that they might find it harder to switch or get a better deal elsewhere. So that's a little bit of the background to the proposals, but what actually is the consumer duty? Well, it's actually a package of measures that comprises 3 parts. And I've borrowed the FCA's little infographic here because I think it's quite helpful. So at the top of the pyramid is the new consumer principle, and this will provide an overarching standard of conduct for firms. And this will be supported underneath by a set of cross-cutting rules and then outcomes which will set the expectations for firms' behaviours and cultures. And I'm going to talk a little bit more now about the consumer principle in more detail before handing over to Emma to run through the other 2 elements of the proposals. So the consumer principle is intended to set a higher standard than the current Principle 6, which we looked at earlier. And the FCA is actually consulting on 2 options for the wording of this new principle. Option 1 says a firm must act to deliver good outcomes for retail clients. And option 2 is that a firm must act in the best interests of retail clients. Now, option 1 places the focus on consumer outcomes and the impact of firms' actions on their customers. The FCA does recognise that the concept of good outcome doesn't exactly have an established legal meaning, but it says that the rules and guidance in the consultation paper should help firms establish what good means. And the paper does set out 4 key outcomes, which Emma will be discussing in a minute. But the FCA has said that option 1 would not be limited to delivering those 4 outcomes alone. And the best interests concept in option 2 will be familiar to many firms as it already exists in various parts of the FCA handbook. The paper does note, however, that outside the handbook, best interests is sometimes used in the context of fiduciary relationships. However, the FCA has stressed that its intention is not that the consumer principle would give rise to a fiduciary relationship between firm and customer. So that's level 1 of the pyramid, and I'm now going to hand over to Emma to talk through the other 2 elements.
Perfect. Thank you very much, Lucy. And as I do talk through these other 2 elements of the pyramid, you'll see that I'll come back several times to themes that Lucy's already mentioned, firstly from the broad principles of the consultation and also from the actual consumer principle. So the cross-cutting rules, which, as you'll remember from the infographic, they're the sort of chunky middle bit of the pyramid. Cross-cutting rules, it's not a novel phrase. It's a phrase that FCA seems to use in a lot of contexts now. And it possibly uses it almost as much as those of you who know me will think that I use the word holistic. And in fact, I think there are parallels between those two concepts, that it's looking at things on the whole. If you look at something in a vacuum, you're probably going to miss something, and it's probably not going to get to the outcome that you want. And I think this is what FCA is trying to get at here, that firms, when they are looking at compliance with the broader consumer principle, need to look at what do we need to consider to make sure that we can meet it. And FCA has said in the paper that there are 3 basic behaviours that the firms should be undertaking in order to meet this. The first is to take all reasonable steps to avoid foreseeable harm to customers. And we can unpick this a bit. It starts off very, very wide in that it will apply to firms' conduct, to their products, to their services. And FCA goes further and says, you know, what we're looking at here is that for firms to take proactive steps to avoid harm wherever they can do so. So it's all about understanding customers as a whole, understanding what their vulnerabilities are, understanding where behavioural biases come into play, and understanding where consumers and specific customers might lack knowledge. And I'll come back again to this next point, which is all about giving them information that's fair, that's clear, that's not misleading, that doesn't disguise any benefits or risks in a way that they can't be understood, and that doesn't bury important terms in a mire of documents that you actually know that people aren't going to read. However, it's also important to note that this sounds very, very broad, but FCA does acknowledge that it will not protect customers from all possible bad outcomes. And this could be because the harm in question isn't foreseeable at all, or that it can be foreseen when it's too late to do anything about it, or really because the very nature of the harm means that there aren't reasonable steps that a firm could take to prevent it. So broad concept, but there are the concepts of reasonableness, there is the concept of foreseeability within it. And I think this is probably key to FCA appreciating, well, there are some products that are just too risky. That's not saying that no customer should ever buy the product. It's all about this reasonableness and the foreseeability test. So then the second point is that firms should take all reasonable steps to enable customers to pursue their financial objectives. And here, FCA is recognising that individuals ought to be empowered to be able to make their own decisions, and ultimately they must be responsible for their own choices and the decisions that they make in relation to them and the actions that they take. But what it does expect by this is that firms create an environment in which consumers can act in their best interests. And again, in this part of the paper, it talks about vulnerability, it talks about behavioural biases, and it talks about looking at the harms that might occur if firms have not sufficiently recognised and taken account of these. It says that as part of meeting this requirement, what firms ought to be doing is using their knowledge of consumer behaviour to enable and support them to make the good decisions. And it's quite interesting that in this part, the requirement that's up on the slide says customers, but a lot of the narrative in the paper around this says consumers. And, you know, the difference being that the customer's the individual, the consumer's the general. But I'm guessing that what FCA is trying
Apologies, everyone. I think we've lost sound briefly. We'll just give it a minute and see if Emma can get that sound back. And then if not, Emma, I can move on to the second part of the slides whilst you get connection. Apologies, everyone. We will we'll catch up with Emma when we fix those issues. Apologies. So moving on to a bit more of light relief then. Colin and Cuthbert. I hope most of you have seen the tongue-in-cheek tweets and social media posts about the Colin and Cuthbert dispute. And if you haven't and you have 5 minutes over lunchtime, I'd recommend taking a quick break, just have a little look to cheer up your day. I'm going to look at this dispute through the PR and communications lens and how this tactic can be used in certain disputes. I just wanted to flag that we do have a team of IP dispute experts at the firm who can take you through the IP angle in much more detail at another session if this is of interest. So let's start at the beginning. Colin the Caterpillar was officially trademarked in 2008 in relation to his name and his packaging. About 10 years later, Aldi started selling Cuthbert the Caterpillar. I'm sure you're all aware there's lots of other retailers out there who also sell Caterpillar cakes, including Curly, Clyde, Wiggles. But as far as we're aware, the High Court claim has only been lodged to date against Aldi. Perhaps because once the cake is taken out of its packaging, it's quite visibly similar to the cake. The cake fans among you will also have noticed that last month, Aldi's now changed Cuthbert's face. So for a bit of Thursday fun, using a poll, please can you select which cake M&S have taken offence to? Very interesting result. So it's actually cake A, which is Cuthbert. Cake C is Wiggles from Sainsbury's. It's very interesting for reasons I'll go on to. So Marks & Spencer's claims that Aldi's Cuthbert has violated its intellectual property in Colin. And to do so, Cuthbert must have been identical or have an element of similarity, together with a likelihood of causing confusion to the average customer. As part of the claim, Aldi's been asked to remove Cuthbert's from its shelf and to refrain from selling similar products in the future. Marks & Spencer's may also seek an account of profits made by Aldi in relation to the sales of Cuthbert. In response, Aldi announced that it tends to sell a limited edition version of the cake, with profits going to charity, has sought to join forces with other retailers selling Caterpillar cakes to support its charity partners, Teenage Cancer Trust and Macmillan Cancer Support, who are also the charity partners of Marks & Spencer's. And they've also asked social media if Colin and Cuthbert can be besties. Similarly, the parents among you may have spotted a limited edition Colin cake for Father's Day, produced by M&S, complete with a Batman mask and a cape. So the cake wars are truly on. On a serious note, trademark infringement is not usually something that is presented in the comical way that it's being presented in this case. It's usually a really serious matter because it is based on another business seeking to benefit from another's hard work and reputation, which is often wrapped up in their brand. You'll have even greater understanding than we do as a law firm about the amount of time that the business spends on producing products, marketing and selling those products, especially where there are similar products in the market, and how to make them distinct from competitors' products. So whilst in the legal sphere, many have focused on the merits of the IP claim itself, what's also really interesting is Aldi's PR strategy. So Aldi's created a humorous story of Cuthbert behind bars with a slogan, #FreeCuthbert, which has gone viral on Twitter. And the social media messages appear to make light of the situation, of the legal action that Aldi faces, and seeks to involve other retailers who also sell caterpillar cakes. And perhaps the aim is not only to gain support and promote its product with the public, but also to poke fun at its legal opponent and to try and bring other retailers on board who could face similar court actions for the similar products that they sell, which Marks and Spencer has said publicly it has not ruled out. And they actually seek to try to build a group of defendants, which makes the court action for Marks and Spencer much more costly and difficult to deal with. So how does this tie into financial services and any PR and communications tactics it might use in disputes? So consumers want financial institutions that they can trust and really value well-known brands. So if there is a dispute which affects multiple consumers, for example, PPI claims, which I think most financial institutions have faced and continue to face, a key part of handling such a dispute and to maintain a positive brand reputation is to think about things like how to reduce the noise and the reach of that dispute. So perhaps reduce the number of claims faced and actually the overall provisioning for those claims. How to divert attention to something either more positive or just something completely different to try to increase the number of new customers or to retain the current customers irrespective of the dispute. And also to stave off competitors from using any of the fallout from the dispute to their advantage, to stop them from swooping in on those disgruntled customers. So lawyers obviously advise on the legal implications of decisions and actions, whilst PR professionals advise on the public-facing implications of decisions and actions. So in other words, there are two conversations going on. One inside the courtroom to persuade a judge about the legal merits of a case, and another outside the courtroom to persuade the public. So both professions are required at times to write from a strategic angle, and working together can make a real impact on how a dispute is perceived in the media and how customers react or don't react to the news of a dispute. So a well-judged publicity and communications plan can be really beneficial. Aldi is using the tactic of winning in the court of public opinion to its advantage, and Marks and Spencer have been really slow in responding to those jibes. So Aldi's use of social media is painting the picture that Marks and Spencer is being petty and that all retailers should share a slice of the cake. And the merits of the IP action aside, Aldi are also playing the underdog card. They're creating hype about their cheaper and supposedly inferior product being similar enough to M&S's product that it must be good enough to justify a court action, with a post that Cuthbert has been found to be guilty of being delicious, and also suggesting that money should be spent on developing products to support charities rather than on lawyers, with a quote of, "Let's raise money for charity, not lawyers." I have to admit, that one hurts a little bit. So we've worked with a number of businesses where incorporating a comms plan has been really valuable to handling a dispute and to protecting their reputation, which is often much more important than the outcome of a single or even a group of disputes. The focus is often on what to say, who to tell, when, and how best to say it. And this may include having a variety of narratives or alternative angles ready to utilize at a critical moment in the litigation, or simply getting the message out there before an opponent takes charge of the narrative. One of the issues we see fairly often is what happens if there is no response to a dispute from a business. And what tends to happen is that void of silence is filled with the noise of consumers, which can actually create a snowball effect and have the opposite outcome. So that has to be balanced, though, with attempts to shut down negative noise. As you'll all be very aware, especially in recent months, the focus is very much on the freedom of the individual, freedom of speech, and consumers often resort to the David and Goliath angle against financial institutions and businesses as a whole. And we have seen really positive brand protection outcomes from working together with PR firms, crisis management specialists, internal and external comms teams to really help clients use all the tools available in their arsenal to minimize the disruption a dispute brings. Recently, we've been working with a comms team in relation to a multi-jurisdictional data breach claim and also a racial discrimination claim arising from the hire of a luxury riverboat. So finally, I predict in the social media world that insurers will take an ever-increasing interest in what other strategies businesses are deploying to help limit the impact of disputes, especially in the group action space. So having that sort of plan ready and available to use when there are disputes like this is going to be really, really helpful in ensuring you've got coverage. It remains to be seen whether pressure in the court of public opinion changes the tactics of litigation overall, and importantly, whether Marks and Spencers and Aldi can find a way to collaborate, perhaps over a slice of cake. I'm going to now try and pass you back to Emma, see whether Emma can finish her earlier talk. Emma, can we hear you?
You hear me?
We can hear you, that's great.
Excellent, fantastic. I mean, that is just typical, isn't it? Thank you very much, Bandy, for talking earlier than you expected. My headphones have broken. So I believe where I was just talking to the last bullet here of the which in good faith towards.
Emma, I'm sorry to interrupt. I'm not sure if this is a problem for other people, but you're quite quiet. You may need to be slightly closer to your laptop.
Okay,
I will your speaker. That's great. I can hear you really clearly now. Thank you.
Fantastic, thank you. I clearly need quality control on this. Thank you very much. Yes, so what FCA is pointing out here is that generally there's always going to be that imbalance in bargaining position between the knowledge and the expertise of the firm and the knowledge and the expertise of the consumer. And this is why it's so critical that firms have to act openly and honestly with consumers, because if they don't, then consumers can't reasonably be expected to take responsibility for their choices. And again, as with the first bullet point here, FCA wants this duty to apply across everything, across all of the firm's activities, from their high-level planning of their business down to their individual interactions with customers. So again, it's going to be a mix between how firms think about customers in general and individuals in particular. And looking about what the individual needs when it's an individual case, looking about what consumers generally will be looking at when they're doing their more high-level planning. And again, there's a balance here because FCA recognised that this would sound fairly prescriptive, and it was worried that it would actually force firms into only giving a narrow range of choice, which wouldn't be good for consumers generally. So it stresses that firms should be able to offer choice. It expects that, you know, within what's a reasonable action, there will be many different parts of reasonable action that firms will be able to take. And so in doing that, what it wants to do is embed a concept of reasonableness into every element of the duty. So it will be wanting firms and expecting firms, and understands that firms will need to look at things like the nature of the product or service in question and what the firm's role in it is and its relationship with customers. Because as Lucy said, what it's not trying to do is introduce a fiduciary or advisory relationship where there wouldn't otherwise be one. Looking at the potential to cause harm to the customers, so obviously taking special care over the more high-risk products and services. Looking at the complexity of the product or the service, so products, say, with complex charging structures, it would be reasonable to expect firms to take more time, more effort to help customers understand what they'd be paying. Another key aspect is the role of the firm in the distribution chain. Every firm in the distribution chain will have duties, but what that duty is and what it's reasonable for it to do will ultimately depend on where it is in the chain. And also, of course, what customers will reasonably expect has got to be relevant, because if you have a no-frills product, then it's not reasonable that the customer expects a 5-star service in relation to it. And finally, there will always be those times when you will be looking at the specific customer characteristics, whether it's in relation to a product or whether it's in relation to the customers. And again, FCA is talking here about
but it's recognising that there's going to be different outcomes for different types of customers, and that's fine. And firms just need to be able to identify when some groups of customers might get poorer outcomes, how those outcomes might differ, why they might differ, and what firms could reasonably do perhaps to change those outcomes if necessary. And it also recognises that some of the characteristics of consumers doesn't mean that they will necessarily come to harm, but it might mean that some of groups of consumers will have different or additional needs. So that's the cross-cutting rule. Moving on to the 4 outcomes, which is the bottom of the pyramid. These are the outcomes that FCA says will represent the key elements of the relationship between the consumers and the firms, and where how the firm behaves is instrumental in helping consumers to meet their financial needs. So we've set out in these boxes what those 4 outcomes are. The first is communications, and what FCA says here is that communications are to equip consumers to make effective, timely, properly informed decisions about financial products. And of course, financial promotions, which I'm coming on to next, they are going to be a key to this, but it's more than that. It's about the whole communication with the customer, whether it's what's on the website, whether it's part of the customer journey, everything about how you communicate. And in the paper, FCA picks out various elements that it's criticised many times in the past, you know, for example, focusing on how cheap an overdraft is, but not talking about the cumulative cost of borrowing, hiding key information in a large document, putting it somewhere on a website when it's going to be hard to find, sending out important information really too late for customers to be properly considering it. And of course, in here, you do have to pay specific attention to the method of communication, because everybody knows that a very lengthy web page that requires lots of scrolling down, people just aren't going to read. It may sometimes be appropriate to put something on paper in a different way to how you would present it on a website or on. So, you know, all of this really, I think it's building on Principle 7, it's building on the Consumer Rights Act, various obligations that are already in place, and just building on those. What FCA does say, which is again maybe a little bit of balance, is that firms won't have to check that the individual customers have actually understood the information. They just need to have taken reasonable steps to satisfy themselves that the information was presented appropriately to do so. So the second outcome, products and services, these, unsurprisingly, FCA said they have to be specifically designed to meet the needs of customers and sold to those whose needs they meet. And what it's concerned about here, again, no surprises, is the large, the products on the market that create a high level of profit for businesses, say from late payment fees or relending. And what FCA refers to several times in this paper and elsewhere as sludge practices, the practices that discourage exit from products. So, you know, if it's very hard to exit, if you can't easily find how you exit, if you require customers to go to a branch to exit the product, things like that. And it notes that if you have a product where there's a complex distribution chain, that's likely to exacerbate it. So again, it's looking for behaviour from everyone involved in the chain, from distributors up to the product providers, to make sure that it meets the needs of the customer and to make sure that the right information is communicated to the customer at the right time, and that the product is reviewed at an appropriate amount of time through its life cycle, just to ensure that it remains appropriate. Again, not all of this should be new, most of it shouldn't be new, most of it should already be in the prod part of the FCA handbook. So firms that comply with that, it thinks, shouldn't have to do too much else. The third element is customer service, and FCA has worded the requirement such that the customer service has to meet the needs of consumers, enabling them to realise the benefits of products and services and act in their interest without undue hindrance. And again here, it goes back to mentioning the sludge practices that deliberately hinder customers from taking action that would benefit them, and it wants to be able to see that customers feel they can confidently engage with firms, both pre-sale and post-sale. And so again, what it doesn't want to see is firms putting in really cumbersome practices that are actually going to discourage customers from contacting them or. And then this all moves into the last outcome, which is price and value. You know, obviously we've recently seen the insurance pricing metaphors, but you know, it's everything. It's around every financial product that the price of the products and the services have to represent their value for the consumers. So where does that leave us? Well, it ought to leave the consumer having confidence that the financial products that they buy are fair value and are designed to deliver the benefits that the consumer expect, and that they have received clear information which enables them to do that. They should be able to feel that they have been able to properly assess what meets their needs, and they should feel that the firms they're engaging with engage on a proper basis and are there to help them. And what does it mean for firms? Well, firms will themselves now see the onus on them to show that they're complying with the principle, the cross-cutting rules, and delivering the outcomes they deal with the customers. And firms will see the onus on them to be monitoring, to be testing their processes and procedures, and be ready to provide evidence of compliance if the FCA comes to ask them. It should really both the compliance with the principle, the compliance with the cross-cutting rules, the compliance with the outcomes, the monitoring, the evidence, the audit, the checking, that should really all be part of compliance with the principles. And, you know, we've already referred to them and the overlap with a couple of things, particularly Principle 6 and Principle 7. And I think, you know, where we're at the moment is that FCA isn't yet ready to get rid of Principle 6 and 7. It thinks that the right place for the consumer duty in the Act is as part of the principle. And I think its stance is probably that if you're complying with the consumer duty, then you will be complying with Principle 6 and 7. So there isn't duplication and there certainly isn't contradiction. We'll see. Now, just the final aspect of the consumer duty that I wanted to talk about before I go on to the last part of our day is the private right of action. The proposals are seeking views on the introduction of a new private right of action, which would give individuals remedies if they feel that the firm has failed to meet the consumer. Reading the paper, it looks to me as if FCA's jury is pretty much out on this. It wants to weigh consumer protection against the risks that firms will face. As I said before, what it doesn't want to see is firms really scaling back on what's available because they're scared of what might happen to them, thereby reducing consumer choice. So that was what we wanted to say on the consumer duty, and I just thought I would leave that picture of cakes there for a minute while we go over to the last part of the talk, which is an update for you on what's going on in the world of financial promotions, because it may not have escaped some of your attention. There's quite a lot going on at the moment. Before I start, our last little poll of the day, you can answer as many of these as you like. Do you think that the current financial promotion regime works well? Do you think the financial promotion restriction kicks in too early? Do you think there should be more exemptions to the restriction? Do you think there should be fewer exemptions to the restriction? And do you think firms should have a specific permission if they want to options for others? Very interested to see to be there. When I started to create this poll, it was before the Treasury paper that I'm going to be speaking about. So yeah, interesting. You know, some people think that the regime does work well. I don't think anybody really thinks that there should be more exemptions. There are some cases where you feel surely this should be exempt, but it isn't. But I think on the whole, those results reflect what I thought. Some people think fewer exemptions, and some of you do think that firms need to have a specific permission. So here we go. I just thought I'd go back to basics for a couple of minutes. And just a reminder on, well, what is a financial promotion? Because it is very widely defined. It's an invitation or inducement to engage in investment activity. So it kicks in at the earliest stage of engagement, and that is part of the issues that have arisen. So where you have a financial promotion, you have section 21 of FSMA, which says that a financial promotion must either be issued by an authorised person, approved by an authorised person, or be exempt. And in terms of authorised persons, whether they're issuing their own promotion or approving somebody else's, the requirement is that overall it must be clear, fair and not misleading, and that goes throughout any type of promotion, no matter how short, how long, how detailed, but depending on the product, there are obviously a number of product-specific requirements for content and disclosure. What can go wrong with a financial promotion? Most of the things really that can go wrong generally with everything, I think. Risk of consumer harm. How can consumers be harmed? Well, if an ad has not been approved, it is more likely to be misleading and not contain the information that it should do. If the ad doesn't pay sufficient attention to high risks within the product and services, and if the ad goes to the wrong audience or an audience that lacks the experience for the particular product or service advertised. Fairly much standard that you'd expect. So FCA have been focusing on this, obviously with consumers at the height of its concerns as always. What does it want? It wants to make sure that consumers are protected from the potential harms of investing in inappropriate high-risk investments. And it's done quite a lot of work already in segmenting the market so that even authorised firms are restricted from promoting certain products. But it's gradually come to realise that for these type of investments, technically, even compliant promotions might not be enough to actually deliver the consumer protection that is required. So both Treasury and FCA have been quite active in this, and this little timeline shows what Treasury has been doing. And almost exactly a year ago now, it issued its first paper where it was proposing that actually one of the main problems is that any authorised firm can currently approve a financial promotion. And it mooted the idea, well, is that actually the best thing? Should it not be that firms have to have specific FCA consent, or should there not be some kind of a gateway through which firms should pass before they're able to approve promotions? And it left that there. It issued a paper on particularly the risks of advertising crypto products and the risks of advertising direct-to-market issuance of non-transferable debt securities. And all this is part of the war against mini-bonds and the dichotomy between mini-bonds that count as transferable securities, those that don't, those that count as equities, those that count as debt securities, those that fall within current restrictions and those that don't. come back to this in a but just a couple of days ago, Treasury then issued its feedback statement and what it is going to do about the Financial Promotions Gateway, and it confirmed that it is actually going to introduce one. So what's this going to look like? Well, all authorised firms will have a requirement placed on them, and this will show up on the FCA register, that they are not to approve financial promotions. And if they want to approve financial promotions, they will have to apply to FCA for a variation or a cancellation of that requirement. Now, the idea is not, obviously, that firms will have to apply to FCA every time they want to approve any specific financial promotion, but the idea is that they can say they want to vary the requirement only to approve promotions for certain products, which arguably should be products that they well understand and that they advise on. So that's going to be the basic stop. Unless you've got FCA consent, you can't do it. As ever, there will be some exemptions, and the key ones that Treasury has said will be in place are for firms which are approving financial promotions for other companies within their group, and for firms which are approving financial promotions for their own elected representatives in relation to activities which they provide the appointed representative a regulatory umbrella to do. And how and when is this going to happen? Well, it's like as soon as parliamentary time allows and in due course. So we don't exactly know, but what we do know is that there is of course going to be the usual transitional period. And what will happen is that firms will have a transitional period during which they will have to tell FCA that they want a variation or cancellation of the requirement. And during this period, firms can just continue to operate as normal. Then there'll be a period when FCA is considering the applications, and during that period, only firms that have made an application can continue to approve. And then obviously, once the approvals are through, firms will act in the terms that they have agreed with FCA. And, you know, much like variations of permission, firms will be able, obviously, to apply to FC at any time for a variation or indeed an imposition of the requirement. Meanwhile, FCA has been issuing various papers, and all these really come back, I think, a lot to the consumer duty. You know, what are FCA's concerns? It's about making sure that customers, when they look at promotion, are able to understand and assess the key elements of what's being offered. So the features of the investment, the likely costs of it, the risks and benefits, and whether the investment will meet their needs. The way that it's drafted should make consumers understand what actually is risky, because one of the many research papers that FCA has put out shows that, you know, the too good to be true belief, they think the threshold is actually too high, and, you know, investors do believe a lot to be true, but they really shouldn't. So something has to be done there. And also, it is key, you know, not to stamp down on everything, but to encourage diversification in the consumer investment pattern. So the FCA rulebook at the moment, in various parts of COBS, is really quite complex to navigate in terms of financial promotions. FCA has categorised investments so that it does give, hopefully, the right protection to the right sort of customers, and in fact ban promotions at all of certain investments to some sort of customers. And at the moment, I guess it's got maybe three main categories of high-risk product. It's got the non-readily realisable securities and peer-to-peer agreements, which marketing is permitted only to restricted investors and is subject to appropriateness requirements. Then it's got the non-mainstream pool investments, which of course has been subject to much debate about what's actually included within those. And the more recently introduced speculative illiquid securities, which are subject to a general mass marketing ban and to a suitability assessment if they are to be marketed to high net worth or self-certified individual investors. And then there are product-specific rules that I've already mentioned for particular complex products. But FCA is not sure that this is actually right. It wants to consider whether other things should be high risk, whether the investor categorizations actually work, and whether the approval process works. In particular, it thinks there's a lot of investments which work and have a similar overall economic effect, similarly risky to some of the current high risk investments, but which are not currently categorized as such. So it's asked a number of questions in its paper. It wants people to tell it, are there any investments that aren't restricted and should be, such as some listed products, which actually are quite risky? What about not only the non-transferable debt securities, which are the subject of Treasury's consultation, but also equity shares that actually, to all intents and purposes, act in exactly the same way as units in unregulated collective investment schemes? And what about peer-to-peer agreements that actually have similar features to those? Should there be a rethink of the categorizations? It wants to know whether respondents think that all readily realisable securities are, by their very nature of being readily realisable, are they safe, or is this not right? It is concerned about self-directed investors. It is concerned about the high net worth and the self-certified sophisticated and what they're actually signing up for and whether they actually understand what they're doing. And then it is particularly concerned as well, and I think understandably so, that the increasing restrictions put on authorised firms within COBs has a knock-on effect that firms are scrabbling around trying to fit ads that they might otherwise have had approved within an exemption, which might not be designed for it, and obviously can cause damage when something that shouldn't fall within an exemption is treated as such and an authorised firm isn't involved at all. So, you know, there are problems whichever way you cut the cloth, as it were. So what might FCA do? I mean, obviously, we've got the last box on this slide, which is the gateway. It's going to have to work on implementing that, and that quite a lot of difference. And I'm almost going backwards here in the boxes, I think, because again, much as we've talked about in the consumer duty, you don't want to place too much on firms, that firms will pull out of markets, leaving little choice for investors. Here, you don't want to put so many requirements on approvers that they will consider it uneconomic to do. And you don't want to force too much, but maybe you want some involvement with approving firms on the underlying investors so that they can understand whether the way that the promotion is drafted is actually suitable for the intended market. So within that, FCA will also be considering, as I mentioned, you know, whether it will put in place more categorizations of restricted products, whether it will add products to existing categorizations, and whether there do need to be tweaks to investor categorizations and what is allowed to be promoted to particular particular types of investors by reference to the particular type. So thank you for bearing with us as that didn't quite go in the order that we had planned. I'm pleased I got my microphone back in the end. I would like to thank Mandy and Lucy very, very much for their contributions, especially Mandy for jumping in earlier than required. We have a few minutes left for our questions. Just looking to see. So, I mean, I think we've got a lot of interesting things on the horizon. And I think that we can see that so many of the initiatives that have been taking place just interact with each other. We've seen also that even this morning, a few more pieces of the Financial Services Act 2021 that Lucy mentioned have come into force. More enabling powers will be happening. We can see the ambitious deadlines being set. I really think the rest of the year is going to be quite an exciting time. So, said all that, we will be back with you in September. Watch this space for the topics we will cover. We've already got some ideas. We always have ideas. And thank you very much indeed for joining us today. Keep in touch with Finn and get in touch with us if you have any points. So thank you very much indeed, everybody, for joining us.
Thank you.